Okay. Good evening, everyone. It is 7 p.m., so I will call the regular meeting of the governing board to order at 7 o'clock. Roll call shows that all members are present except for Mrs. Julie Reed, who had a family obligation this evening. If you please stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. And a moment of silence, please. Thank you all. Mrs. Ordway?
Yes, I would move that we adopt the agenda as written.
Do I have a second?
I second.
Thank you, Mrs. Paperman. All in favor, please say aye.
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 Any nays? Hearing none, the motion passes unanimously. We have no public comments this evening, and we will move into our first item of business, which is discussion, and that will be open meeting law, training, and discussion. And tonight we have with us from Arizona School Boards Association, Mr. Chris Thomas, an attorney, and I'm going to let him tell everyone a little bit about himself and then start us off with our training and discussion.
Well, thank you, President O'Brien, and good to see everybody. My name's Chris Thomas, as Ms. O'Brien said. I am the General Counsel and Associate Executive Director for the Arizona School Boards Association. I have been with the Arizona School Boards Association for about 21 and a half years. I started as a lobbyist with them and then became their legal counsel and had that position for a little over 20 years. So been with the association for a long time. My background is I'm a longtime Phoenician. I grew up not too far away from Deer Valley School District on the west side of Phoenix, and went off to Tucson for college and then off to Nebraska for law school, and always knew I wanted to come back here and practice law and to do something in public policy and hopefully in education as well. So that it worked out terrific that I got to work for Arizona School Boards Association and do something that I'm very passionate about in supporting public education, because without public education, I wouldn't be the first person in my family to go to college or become an attorney. So I feel like any way we can give the opportunity for others and work to do that, that's what I'm all about, and love to do that. So, and I love to educate school board members, because I have a lot of, still to this day, after all this time, I have a very soft spot for school board members. I've known so many of them, many have become friends. I just have a lot of respect for what they do. The fact that they are giving of their time and are trying to make their communities better and trying to strive for student achievement in their communities and support the hardworking staff that they have. Again, I just think they're just the salt of the earth and among the best people that are out there. So, and getting a chance to educate them about things like open meeting law and kind of the public governance side of things, legal issues, that's still a joy to me to do. So
Chris,
with
before
that,
you start,
yeah.
Sorry, real quick, I forgot to talk a little bit about our format tonight. We're going to let Mr. Thomas get through his presentation of this topic, and then we will have questions and discussion. So board members, if you can write your questions down as you go, and then we'll hold them till the end, and then we'll start over again with our board policies. Thank you, Mr. Thomas.
Sure. So with that, let's jump into it. I do a lot of open meeting law trainings. I think I've got 3 this week. So it's not a topic that I'm I'm very familiar with. So I am going to share my screen. I have to apologize. I hope I don't have any glitches. I am a master, I feel, at this point, after a year on Zoom. I'm less so on WebEx, so hopefully it'll work with me as well. So I will share my screen here, and hopefully that'll work. Where's my? Is there a way to share my screen? I've got it pulled up on my screen.
You should be able to, if you go into your settings at the bottom,
Gotcha.
share your screen.
Got it. I found it, and
Okay.
I'm looking to find it right now. Okay, there we go. Everybody see that? Okay, great. It worked. Okay. So that's who you are, and that's the date, and that's who I am. So let's get started. So I always say to everybody when and many of you I know have seen an open meeting law presentation before, but I always start by kind of framing why we have this law in the first place. Because I think if you understand why we have it, you're going to understand a lot of the other stuff that follows. And the biggest thing is that, it's really intended as one of our two sunshine laws to bring government out into the open so that the public can see the decisions and the discussions that are being done on their behalf by their representatives. And it's also there to protect individual board members so that nobody gets shut out of the process. It's an open process. The discussions that happen amongst a board are in public. The decisions that are made are in public. And everybody gets to scrutinize that and decide for themselves how that board's doing and whether or not they agree with the decisions that are being made on their behalf. And so once you understand that it's there to protect the public's interest, it's not the interest of the board members or the school district or school employees, although many times they're, it's helpful, some of the things that are in the law for those individuals. Really, each issue comes down to protecting the public's interest. And so, again, framing the law that way makes it easier to understand, and that the public policy of the state is to favor open meetings. And that's a really important one because it's actually baked into the law. It's in the statute. And if there's a question of application or interpretation of the law, that's what the Attorney General or a court will use to determine whether or not something should be in the open or how the open meeting law ought to be construed. Okay. This is going to move, right? Okay. There we go. So then when does the open meeting law apply? It applies when there's a quorum of board members of the public body. And this includes what we call instrumentalities of the board, and I'll get into what that is. So what's a quorum? A quorum is basically a majority of your board as it's presently constituted. In this state, most boards are 5-member boards. We do have some 7-member boards. We still have a few 3-member boards. So in your case, you have 5 members and everybody you don't have any vacancies, so it's going to be 3 members will trigger the quorum requirement of the open meeting law. Instrumentalities, as we said, are subcommittees, and we'll get to how a subcommittee is created and what the law is for those as well. But know that it's not just when you count quorum to find out whether it's present at any one time, it's not just 3 people in the same place at the same time. Obviously, you all are not in the same place at the same time right now, but this is an open meeting. This is a law covered under the open meeting law. Why? Because we're meeting through technological means over a technological platform in which the public is allowed to watch. Therefore, we have a quorum here, and we're going to be discussing board business. So this is a meeting that's covered under the open meeting law. So a couple of things just to keep in mind. You can't vote by proxy. So under the law, if you were not able to make a meeting, but it was an important vote, you couldn't give your vote to another board member. A lot of corporate meetings and things like that, that's not like that. You can give your proxy to someone. And as we mentioned, physical proximity is not required. You can trigger the open meeting law requirements even if you're not in the same place at the same time, or even at the same, where you're dealing with multiple conversations over a period of time. And we'll get into that in terms of what a serial conversation is. And your policy references BE, that's your school board meetings are covered under there, including the open meeting law. There we go. So the second thing is you have a quorum, and we know that it applies, the open meeting law applies when you have a quorum, but there's a second component that's also required for the open meeting law to apply. If you had, for instance, a quorum of board members that were talking about something that had nothing to do with the school, if they were talking about, families and personal issues, that's still not under a meeting under the open meeting law, because you don't have the second component, which is that you're discussing or taking legal action or deliberating with respect to any legal action about something the board could do something about that's within the jurisdiction of the school district. When you have that second component and you have a quorum, you have a meeting under the open meeting law. And that distinction is really important, because what happens is since we define what a meeting is under the law, the question is, do you have a legal one or not? Because even if you haven't posted for a meeting or planned for a meeting, if those two things are present, the law defines you have a meeting. But because you haven't posted for a meeting and the public hasn't been told this is happening, you've got a violation of the open meeting law. So a meeting could also include, or at least the open meeting law could be triggered by a single member of the public body proposing legal action to a quorum of board members. This particularly comes up with an email. So, say the superintendent sent, a Friday update, and a board member, in reacting to that, replied to the entire board saying, I think we ought to do something about this issue. And they essentially propose action by the board to a quorum of board members. Now, the rest of the board members don't have to respond to that. They can understand that that's a violation of the open meeting law, but it would be a violation for that individual board member that proposed legal action to a quorum of board members, even if nobody responded. But email is really important, because if you have an exchange of communication amongst a quorum of board members, which involves any discussion or deliberation about something that could come before the board, then you've got a violation of the open meeting law. So you really want to make sure that there's not communication in a collective sense in any fashion over email. And the new thing is, I realize I'm dating myself, by the way, when I say that. The big focus now is text messaging. If you've got a group chat with the board, don't have a group chat with the board. That's going to be a problem right away. First of all, you know that it is a public record. Somebody's going to have to maintain that record and produce that record if it's requested. But also, you've got a real easy open meeting law violation. There we go. So we talked about a series of discussions can lead that lead to an agreement can violate the open meeting law. And this is our serial conversations problem, where you've got one board member that talks to a second board member, and then the second board member then goes and talks to the third board member about the same issue, and that's what we call a walking quorum. And if there's deliberation there about that issue, you've got a violation of the open meeting law. And so what I tell people, in interpreting the open meeting law, it doesn't mean that board members can't talk to one another. You just need to know, if you have a conversation with one board member in a 5-member board, you can't have a similar conversation with a second board member, because that will create an open meeting law violation. And it also means that you should involve your superintendents, and there's good reason to involve your superintendents anyway when you're dealing with board business, because they're part of the team. But the superintendents can really serve as an information hub. So if you have information that you'd like to get out to the rest of the board, or the superintendent has information they want the board to get, that superintendent can make sure that the board gets that information, and then does it in the right way, that we don't have an open meeting law violation. Sorry, there's a delay in my thing. There we go. And so that's the other thing. So if governing board members cannot direct staff to communicate with other board members, if that if that communication wouldn't otherwise be allowed, you can have a problem where if one board member goes to the superintendent and says, I really want to offer this amendment to this because I think it's a good consensus position, but I don't want to offer it unless the other board members are on board. So when you talk to the other board members, could you see if they are? And if they did that, then it's a violation for those board members that are involved in that conversation. It's also a violation for the staff member that's involved, the superintendent that's involved in that. So it's one thing to share information, and I certainly don't want to say that it's not a great practice for superintendents to meet with board members in ones or twos. But you want to make sure that you don't relay the substance of those conversations to other board members in a fashion that would create a collective conversation. So another thing that, and I don't think we have a lot of new board members here, so this should be familiar to you, but it doesn't matter what you call your meetings. If you have a retreat or a work study or a regular meeting or a special meeting, emergency meeting, the open meeting law applies to all of them equally. And so this is really important when it comes to retreats or work studies where, you're not going to make any decisions. The agenda is a little looser. You may have things that come up that relate to the agendas at hand. But you need to make sure that they do directly relate to the things on the agenda, because if they don't, we got an open meeting law violation. So just know the rules are the same no matter what you call your meeting. It also applies to subcommittees. And so I do want to mention what a subcommittee is for the purposes of the open meeting law. The subcommittee for the purpose of open meeting law is one where the board has created the subcommittee by motion of the board, or by directing or the presiding officer has created with authority from the board a subcommittee. Or by policy. If it's in policy, many boards, it's less common now, but many boards used to have a sort of standing, thing on there where they had some standing committees. Then those standing committees and policy were also covered under the open meeting law. So. Okay. I'm collecting a lot of noise. You know what I've got? I've got a fan on behind me, and I bet you it's making some noise. So, boom, there we go. Better? I hope that's better. Okay, so just remember that it's anything that could come before the agenda and anything that could come before the board, and then just watch appearances. When I say watch the parking lot, you want to make sure that even though you're not violating the open meeting law, if you're having a personal conversation amongst three board members, if it's in a public place, people will assume that you're violating the open meeting law, and it's just better to just avoid those kinds of things, those kind of appearances when you can. So that's what we suggest to everybody, and especially if you're going to all be going to district events. If you're going to district events, you want to, that's why many districts do what they call soft postings, a list of events in which a quorum of board members may be attending, but no board business will be happening. So just some logistical concerns to be concerned about with the open meeting law, that you have to comply with the following, your location of your meetings, the notice of when your meetings are going to take place, the agenda requirements, and the minutes, and I'll take each one of these individually. Your location should be at any public facility in the district, and these days, of course, we're doing a lot of meetings online. Access is really defined in a different way, through, doing live streaming over a different platform, or making sure that everybody understands how to use the technology, or providing assistance to everybody to use that technology. You can have special meetings that are not in district location, but you should not take any legal action if you're not in a public facility in the district. Now you can have a retreat where you have a discussion about things and maybe some strategic planning and things like that. but ultimately those plans ought to be adopted at your next meeting in the district office, at the board meeting. Your notice is where you're going, there's two parts of your notice. The first one is where you're required on your website to post where you will be posting your meetings when you're going to have a meeting. And it'll say, we're going to post it here on the website, and we're also going to post it in some physical location in the district, and here's where it is. And then the other part of notice, of course, is actually doing that when you're going to have a meeting, which has to be posted at least 24 hours in advance. Can everybody still hear me, or am I rustling? I will lose my headphones if that's a problem. Okay, better? Okay. And then, so the 24 hours in advance is important because, again, you're putting the public on notice. Hey, we're going to have a meeting. Here's where it's going to be. You know, if you want to attend, you can attend. And then you have to have written notice delivered to board members at least 24 hours in advance. The law encourages you to give notice additionally that's reasonable and practical, that provides additional notice. We just urge everybody not to make that part of their official notice, because especially in a district the size of Deer Valley, with how many schools you have? Probably 50, something like that. Something like that.
9.
So 59?
39.
39. Okay. Well, you're going to get there. There's no question. I've seen your growth, projections. But 39 districts. Imagine if you said our official notice is going to be posting at every school site, our agenda and our notice, and you have defective notice almost every time. It's really, really tough. So do that if you want, but don't make it part of your official notice. The agenda is posted with the notice, and that's where you talk about, you list what you're going to talk about at the meeting, what you're going to decide at that meeting. And you have to be specific, and you have to describe that information in a way that a person off the street can understand what the issue is going to be. Because you are, limited to those items that are on the agenda and those that are directly related to those agenda items. So it's really important to get that list right and get it fairly described. And it's always good to have at least a second pair of eyes on that to make sure that you've satisfied the legal requirements there. And we'll talk about exec sessions when we get there. You also have to have minutes, and most people kind of glossed over this. Everybody assumed you have to have written minutes, and most districts do have written minutes. It's a good practice, but a recording of your sessions can also serve as minutes. And this became a very helpful thing about this time last year, when people realized that it was we're doing virtual meetings, and it was not as easy to produce the minutes because staff was out of the office and things like that. So you can record your meetings and have that suffice as your minutes, either permanently or temporarily while written minutes are being created and ultimately adopted. But either way, you've got to have one of the two, either written minutes, including in a draft form, or a recording of the minutes within 3 working days of the meeting. These are the basic requirements of your minutes. It's basically the date, time, and place, who was there, who was not there, a general description of everything that was considered, and then a very accurate description of every motion that is made, including who made it, what was discussed about that, and then who seconded it and what the vote was. And so also include the names of persons who make statements or present materials to the board. There's no requirement for you to approve the minutes, but most districts do. It's a good practice because that's the best way to make sure that it's accurate. Again, I mentioned that they have to be available for public inspection within 3 working days. You have to keep a recording of your minutes. So most districts do a recording, and then they do a draft written minutes, and then the board adopts the written minutes, and then you have to hold on to that recording for 6 months under the retention requirements of the public records law. But your official minutes at that point, once the board has adopted it, are those written minutes. And we'll talk exec session minutes in a minute. So we're down to a fourth rule, and they go a little faster from here. The first one is just basic procedure. That there is, a formal calling the meeting to order, that you follow all your policies, you cover all the items on the agenda, and you can change the order unless it's time specific. So one of the things that we encourage folks to do is utilize that adoption of agenda that most districts have. Most people kind of gloss over it, but if you're going to change the order of things, it's a great time to make a motion to say, I move that we adopt the agenda with the following changes, and say, I would like to see item 6 be number item 2, because lots of people have showed up for this discussion, or that we've got word that the administration is not ready to move forward with item 8, so we want to table that item. And you can do it all in one motion. If you know what, if you've done your planning and you've talked to the administration for updates and things like that. You obviously have to cover only those items on the agenda, and then anybody who speaks to the board, whether it's staff or members of the public, that they identify themselves and spell their name if it's some unusual spelling, to make sure that they're accurately reflected in the minutes. And then you formally adjourn your meeting. So you sort of have a beginning and a middle and an end. And then our fifth rule is what citizens' rights are under the open meeting law. And even though this is a public interest law, the law does not require public participation under the open meeting law. Most districts do allow public participation, but it's under district policy, which allows you some flexibility about how you shape that and what that looks like. So under the open meeting law, the citizens do have a right to attend and to listen. They have the right to record you, and they have the right to expect you to follow your own rules. And they do have the right to address the public body if your policy allows for it, but otherwise there's no right to participate. And so also at this time of virtual meetings, I think also embedded in there is the right of real-time access. So initially when a lot of folks were sort of grappling with the technology, many were considering recording their meetings and putting them up on YouTube and thinking that that would be suffice for public access. But I actually think that the open meeting law requires real-time, access for the public, not to just see some recording of something that already happened. You can conduct an open call to the public, but you need to understand if you have an open call to the public, which includes not only issues that are on the agenda, but also issues that are within the jurisdiction of the district, but may not be on the agenda. If it matters not on the agenda, that you cannot take legal action or discuss the issue with a member of the public. And that is kind of a tough thing to do, as many of you have found out. You can always limit comments to items appearing on the agenda. That's what we call limited call to public. And there are a few districts still out there that do that. If somebody speaks in a call to the public and it does and the item is on the agenda, the board and the administration is allowed to engage with that individual legally. You may decide for yourself that that's not a good idea just for the order of your meetings, but legally you can. But where we have the issue is when somebody raises an issue that's not on that night's agenda, where you basically have to say, thank you for your, for coming, and we appreciate it. And unless they're, you can have them, have the staff review the issue, or get with them to give them more information, or you can say, this is a great issue. We'd love to put this on a future agenda for discussion. And then there's the provision that you can respond to criticism. And generally, we're talking about personal criticism that's been made by those that have addressed the board. And you have to do that at the end of the call to public. So here's an example of what I suggest to people how to use this, which is that somebody levels personal criticism against you, questions your motives, questions your sincerity on an issue or something like that, questions the process and makes some maybe factual mistakes along the way. At the end of the call to public, you can ask the chair, can I please respond to this gentleman that made this comment, because I want to correct the record in the sense that no, my daughter does not go to that school. You got some bad information. Or, no, this is not the first time we've dealt with this issue. This is the fourth time we're dealing with this issue. Those are the kind of things that you'd want to correct the record on and not let stand by those that make comments that are just, not grounded in fact. Now, I would not want to go into utilizing this to, if people just say, just kind of generally, critical comments, they're entitled to do that. It's really where they step over the line or they create a false impression that you want to correct. The board can enforce and adopt reasonable time, place, and manner restrictions and regulations. And this is basically, everybody gets 2 minutes so that we can get as many comments as possible, or that the full comment period will be an hour, or that we're not going to allow profanity or anything that's obscene or abusive. Those are all fair kinds of regulations that have been not seen as an infringement on the First Amendment, because that's one of the things you need to understand is when you do create this call to public, you've created a First Amendment zone, a public forum for First Amendment analysis, and so you can't block the comment because you don't like it, its viewpoint. So just keep in mind that this is something that you want to be aware of, because we've had districts that have said, or boards that have not wanted to hear negative comments about certain things, but they would entertain comments that were positive in those areas, and that likely would be seen as sort of a content or viewpoint restriction, because if you allow content that's positive in one area but not negative, that's a viewpoint kind of distinction. The next one is there's an exception to the open meeting law of requiring that everything that's on the, that in order to be suggested or discussed, it has to be on the agenda, and that's the superintendent or board member report. It's intended to be a summary of current events related to things that generally do not want engendered discussion amongst the full board or amongst the staff or things like that. For the superintendent, it's sort of staff recognitions, student recognitions, kind of an update about things that you don't think the board's going to have a lot of questions about. Especially recognitions if you have sports teams that are successful, or you've got some programs that you want to highlight, staff recognitions, those kinds of things. For board members, it may be things that you did in as a board member in between meetings that you want the rest of the board to know about, or information about a topic, and letting them know that you learned something about something and they can get more information if they want to hear it. But what's important is that the board not discuss those issues, or even if it's clarifying information. It's a one-way communication. If it piques an interest and you think it's something that you would like to discuss, ask for it to be put on a future agenda. And particular superintendents, I encourage you that if you know what you're going to talk about in this area, in advance and in a timely way before the meeting agenda goes out, you can always bullet them under your report, and that gives you the flexibility to answer questions and for the board to discuss them if they want to. So you just need to make sure that you use it for the right things, and that there's no discussion, and that only a board member or superintendent can do this, and there's essentially no handoffs. The superintendent can't say, as part of my report, I'm bringing up Principal Jones to give a report from his school. That's something that ought to be on the agenda, because those that are from that school may want to attend that meeting or hear that meeting, and it's really only the superintendent that has the authority to give that kind of report. So if you're dealing with staff reports, this deals with just kind of what they ought to look like. and know that these kind of reports still are not, these still need to be on the agenda in order to be able to discuss them. Your executive sessions, we'll get into that now. The definition of an executive session is it's a gathering or quorum of members for which the public body, for which the public has been excluded. And it can occur if only one, if it meets only one or more of the 9 authorized reasons in law. And then all procedures are met. And we'll go into the procedures first. Procedurally, you have to call the meeting in order before making a motion to go into executive session. And the notice that the board may go into an executive session for that legal basis has to be on that night's agenda. If it's not on that night's agenda, you can't do it. And that statutory notice, and I know you have a great, board secretary, so she knows this really well. It's got to be, down to the letter. It's, if you're talking about personnel, it's, 38-43103A1. And if it's legal advice, it's 03-A3. So they've got to be that accurate. And then they also have to include a description that lets everybody know what it is, but doesn't defeat the purpose. And then there's a vote to go into executive session, and then the majority votes to go into executive session. During the executive session, only those people who have a reason to be in the executive session ought to be there. Typically, this is the superintendent and board members, and then maybe 1 or 2 other people that have a function in that particular executive session. What's really critical is that all participants are reminded that the discussions are confidential, and you can't take a straw poll or a preliminary vote in executive session prior to deciding the matter in open session. After the executive session, of course, the final vote or decisions in open session. There are 3 exceptions to this. One is that you can instruct a third party with regard to litigation or settlement discussions, negotiations with the employee organizations, or negotiations for the purchase, sale, or lease of real property. And then you conclude with the remainder of your meeting after the executive session concludes. And by the way, the executive session concludes when you motion to go in, reconvene open session. So there should be no motions in executive session, unless you're doing student discipline. That's the only other time you can do that. So our 9 authorized reasons for an executive session are to talk about certain employee matters, to get legal advice, to discuss records that are exempt from public inspection, or they're basically they're not public record, or they have to be confidential. If you're involved in any contract negotiations or litigation or settlement, if you're going to give if you're involved in negotiations with your employee groups and things like that, you can do it for that. If you're involved in any international or interstate negotiations, purchase, sale, or lease of real property, and then the 2 new ones that were added last year: school safety operations or security plans or systems. And I'll mention something about those. Excuse me. So a couple things about some of these that are most likely to have. The first one, by far, is the most common one, is when you have an employee authorization. And keep in mind, it's to talk about an identified employee, not a position. So in your 39 schools, if you were to, you be in a unfortunate position of having to cut costs, and you had to pass a new position or a requirement that said that, in elementary schools of less than this number of students, we're no longer going to have assistant principals. Okay, that wouldn't be an employee matters exception under the open meeting law, because you're talking about a position. You're reclassifying your organizational chart, in other words. That's an open session discussion. But if you had in mind a particular assistant principal who had some disciplinary problems, then you could do that. And if that person was going to be discussed in executive session, they're entitled to receive written notice that they're going to be discussed in executive session at least 24 hours in advance. And then they can say, no, we want this discussion in public. That's their right. And then they otherwise don't have a right to attend the meeting, though you might allow them to attend the meeting, but I would only do so after you're getting legal advice from your attorney. And then the employee otherwise has a right to review the minutes of the executive session for which they were discussed. If you're going to do a superintendent evaluation, which are often done in the executive session, make sure you're doing it based on the personal performance of that superintendent and not having a long conversation about district goals or programs, which should be happening in an open session. If you're going to have a legal advice executive session, make sure your attorney is there or on the phone, and make sure that the conversation is flowing directly to the attorney, asking them questions, allowing them to give you your legal advice. And then once that attorney is done, unless you've got another legal basis for having that executive session, the executive session needs to end. If you do any kind of meet and confer process, even an informal one, collective bargaining, where you're going to give some marching orders to the person engaging on your behalf, make sure that you're kind of limiting it to just those salary and fringe benefit issues, and you're not having some broad discussion about the budget, which really needs to take place in an open session. You have to have minutes in executive session, just like the regular ones, date, time, and location, who was there, who was not there, and then a general description of all things that were considered, including an accurate description of any instruction given. And then finally, you make sure that your executive session minutes are kept confidential. Only public body members, the employee that's subject to the discussion, or if there's some sort of law enforcement action, either by the Auditor General or the Attorney General, is that allowed? Are those access to those minutes allowed? So the ninth rule, and you notice in the 9 authorized reasons, one of the ones that you deal with from time to time was not in there, and that's dealing with student disciplinary matters, including student promotion and retention. So that's because it's not under the open meeting law, it's under Title 15, but it's very much like the open meeting law. There is an executive session, but just understand that the rules are different. I mean, it really is about parental rights and student rights and protecting the privacy of the student, and everything is done for the privacy of the student. So if it's a promotion or retention issue, the hearing and the decisions in executive session, unless the parent requests a public meeting, unless you're going to have a third-party hearing and then get the recommendation. But even if it's done that way, the teacher has to be informed and they have a right to attend the executive session if basically their decision is being challenged. But if it's a disciplinary matter, serious disciplinary matter, like expulsion perhaps, and most of those are being done by hearing officers these days. That recommendation does come to you and it goes in the executive session unless the parent wants it in an open session. But unlike, in the employee context, if the parent wants to be there in executive session, they have a right to attend. And they need to be told when it's going to be and give them, I'd work with them to make sure that it can be done at a time when they can attend if possible. And they have the right to record the proceedings and review the minutes. And since you have high schools, if the student has reached age 18, it's their right to decide that. You can have emergency meetings, and we did have a few at this time last year where you don't meet the regular notice requirements. You just need to make sure it's a real emergency, and you couldn't, and basically say why you couldn't make the regular notice requirements and put that in in your minutes and on the agenda, and then post the agenda or the notice as soon as you can. So what happens if the open meeting law is violated? Maybe you had an improper notice or an agenda item wasn't sufficiently described, or you took legal action on something that you didn't properly notice. Well, what happens is if somebody calls you on that, it's as though that decision didn't have any legal effect. okay? But if you find out, hey, we made a mistake here, we didn't properly describe it on the agenda, the clock is ticking, we can ratify that decision, put it on a subsequent agenda, and say it was based on a prior action because we have been put on notice that the open meeting law may have inadvertently been violated, and then essentially you can ratify that decision. As long as you make sure that you post the details in your minutes and say it's based on a prior action. So if you get to that point and you're trying to do that, work with your attorney because it's very kind of prescriptive and you want to make sure that you do that right. Penalties for open meeting law violation can be substantial. I think the biggest penalty for open meeting law violation, I think, is really just the scrutiny that goes on that board member and on that district and makes it difficult for you to accomplish what you're there for and what you hope to, why you ran in the first place, which is to support students and to do good things for your district. Just because of the, I think the negative publicity that can happen. But you should know that what, kind of individual requirements are on or liability that you may have. It's a $500 fine per violation for a knowing violation or agreeing to aid or attempting to aid another person in an open meeting law violation. And this comes out of your own pocket. There's no insurance that covers you. And then a second offense is a $2,500 per violation. There's a thing that's also put in the law in the last few years that says that, if you're the one person on the board that raised an issue and said, I think we're violating the open meeting law, and you put it on the record and it turns out you were right, you will be treated with leniency under the law. So, if you believe the open meeting law is being violated, it's always good to verbally say so, or at least ask for a clarifying, opinion maybe of your attorney, or ask for the superintendent to weigh in, and then ask that it be put in the minutes. And your last resort, of course, is to leave the meeting. So you can lose your office for violations of the open meeting law. We had board members on the west side of Phoenix about 20 some years ago that did leave, were removed from office because of violations of the open meeting law. And the negative publicity certainly resounded around the state. So it's not a good thing to have happen. So make sure you're asking lots of questions. We at ASBA do an open meeting law training pretty much every conference that we do, just because it's so complicated and folks have so many questions about it, and it's kind of the nuts and bolts of what you do. So with that, I will take a break and take some questions on what we've covered.
I'm not seeing any comments in the chat. I know Mrs. Paperman, you're our newest board member, and so I don't know if you have any questions at this point, or.
I do have questions. So do you want them to be put in the chat actually?
No, we just wanted to know if you have questions, for you to just say, I have questions. So if you have
okay.
questions, I will let you go.
Okay, thank you, Anne. Yes, I have a question. So district events. So how many board members can attend a district event? Does it have to be 2, 3, or it doesn't matter so you're not discussing anything that relates to any future topics on the agenda?
Yeah, great question. It can be as many as you want, and as long as nobody engages any collective discussion about board business, you haven't violated the second part of the open meeting law. But because of appearances, a lot of districts will post all their sort of activities on, in what we call a soft posting, saying that, a majority of board members may attend these things, but no board business will be discussed. And it's just a way of sort of letting the public know that, a majority of the board may attend, but it's not a meeting. And then you just need to make sure that you don't, congregate and talk about board business, because you will be watched at some of those things, and you just want to avoid it. But certainly, I don't want to dissuade a majority of the board from attending any school function. Just need to know what the rules are.
Okay, so another question. I'm a new board member, so yeah, I would like to know if I want to attend, let's say, like the district parent organization or teacher association or any other committee, would I be able to be allowed to attend those committee? Or there's rules for that for board members?
Well, I mean, it's not an open meeting law concern, okay? It may be another concern in the sense that, and you'll learn this if you haven't learned it already. It's one of the first lessons you learn as a board member is that you realize that people will assume you speak for the district or the board, even if you don't speak for the district and the board, and you tell them so. And so and that doesn't mean you can't engage in those kind of situations. You just need to understand that that's how people are going to view you, and you need to be sort of careful that way. In addition to that, you may have your own district policies or board protocols that sort of either assign people to do that or some sort of expectations. Those are the kind of things I think are best that the board have a conversation about and just come to an understanding about, and so that everybody is on the same page about it.
Thank you for the information. That's all my questions. Thank you, Anne. Thank you, Chris.
You're welcome.
Thank you, Mrs. Paperman. Sorry, I think having not heard from or seen any other questions in the chat. Oh, sorry, Mrs. Fisher does. I apologize.
I just actually thank you for sharing open meeting information with us, Chris. I really appreciate it. Just a few things, mostly for Ms. Paperman's benefit or for the public's benefit who's watching, because open meeting is, well, that district where those members lost their seats is a district I was very familiar with and very much remember that story. So simple actions can cause a violation whether you realize it or not, and which is what happened in their case, kind of. So the superintendent, we do have to be cautious with the superintendent and 3 board members as well. It is, in potential for daisy chain or daisy chain meetings or like polling of the board, things of that nature, which you hit on, but that does not prevent 2 board members from speaking with each other or even with the superintendent for the purpose of understanding. So if you could just kind of, correct me if I'm wrong in that statement. And then just a note, we do soft posts when we have events that there's going to be more than 1 board member. For example, we just had our golf event. I'm sure there was a soft post for it. That type of stuff is always done. So for Ms. Paperman, if you can kind of explain to her that it's, well, and maybe she does have an understanding, but I want her to know that we do soft posts for those type of events. And you don't have to avoid the other board members like they have the plague or something. You just don't discuss business with them at those events. So if you could kind of touch on that, you don't have to avoid the other board members at a conference. You just don't discuss district business with them, and it is soft posted. Then I just want to again reiterate that it is absolutely important that you work with at least 1 other board member or different board members. Ms. O'Brien has history of being a real estate agent. If I want to ask a real estate question, I may say, hey, I don't know this topic. Can I discuss this with you? Have you discussed it with other board members? And I know she would say she has or has not, and we would move forward. Same thing with others. I just want to make it clear to Ms. Paperman that it's okay to select a board member and then say, I need to talk to someone about this issue. Have you spoke to anyone? Can you be my one? So if you could touch on that a little bit, Chris, I would appreciate it.
Sure. Yeah, it's not a violation of the open meeting law to talk to another board member on a 5-member board. You don't have a quorum. You can talk about board business. You said, you called another board member and say, did you see this item on the agenda? Do you understand it? That's totally fine. You just need to understand, both of you, that you can't have another conversation with a third board member about that. And so that's all the open meeting law is concerned about. On the issue of events and things like that, that's going to happen, and that's it's encouraged that board members attend district events and show support for the district, and I think that's important. And we don't want to dissuade people to do it. And really, the open meeting law is only concerned about whether or not you talk about board business at those things. So just make sure you don't, and you're good.
Thank you so much, Mrs. Fisher and Mr. Thomas. And I believe we're ready to move on to our next agenda item, which is some of
Mrs.
our
Stokely, I have a question.
Yes, Mrs. Ordway.
I would like Dr. Finch to explain what our Friday update is. So, Chris, you could give us some hints about if there's any changes that we need. And the other thing, I just wanted to make a statement about going to events, because I love going to events, and sometimes we have 3 or 5 people, and sometimes I don't even know how many people are there with the posting. I just want to say that even if there are 5 of us there and it's illegal, that as long as we're not talking about business, that's okay. The optics are terrible. And especially if it comes around a time when there's some kind of a vote, I personally will say hello, stick with one, and that's it. I just, for me, being on the board for a few years, the optics of having 3 people at an event, such as a sporting event or something like that, just it's not a good look. So I was just going to throw that out. But if Dr. Finch could go over the Friday update, that would be awesome.
All right, the Friday update. I've done Friday updates for years as superintendent. This one, we have 2 board meetings in Deer Valley a month, and so we have 2 Friday updates. The structure of them is really a conduit piece for my executive cabinet to get information to the board. What kind of contents would be in there would be if a board member asks a question. I heard that there was a 3rd grader that did this. And if I need to respond to that, what I will do is I'll tell the board member, I'll put that in the Friday update so all the board members get the same information. So that's probably principle number 1. The second part of it is that all my cabinet gives information to the board, kind of like as the word says, update in their divisions. So if it's Mr. Migrino and Ms. Mock, they deal with the finances. And so it might be a finance update from the state. Again, more information and maybe our role in it or Deer Valley's place in that discussion. Again, pretty much by their subject, because they're all subject experts. And so that's the second part of it. And then probably the third part of it is, from my perspective, I will talk about where we're going, things that I've learned. Maybe I was at the legislature or listened to a superintendent meeting, and I learned information that said we need to move this direction to complete this task, or this budget crunch is coming. And so I will put updates, legislative updates, staff recognition, things that actually I probably do a lot in my regular superintendent update at a board meeting. So it's always informational, information for board members to keep up to date. But again, probably the most important function it does is make sure that all board members get the same information at the same time.
Yeah, so, sorry, do you want me to respond to that?
Can I just, you left a part out, which would be some of what is discussed in that board update is not for public consumption for various reasons. So if we could go over that, because I just want to make sure there has been talk or comments about how that the Friday update is possibly breaking open meeting law. And I just want to make sure that we are within the boundaries that we belong.
Okay, so, one-way communication from the superintendent about all the things that were mentioned is not a violation of the open meeting law. I mean, it's a great management practice, keeping everybody on the same page. So that's not an issue that I see, any part of that. I assume this is going out over email. So, just beware if that's how it goes out, is that, that there's everybody understands what the rules are on something like that, that's not forwarded. There's no reply all, there's no reaction, because it's one thing to say, a board member asked me this question, we researched it, here's the answer. We want you all to know what the answer is. It's not an invitation to debate that or to ask other sort of follow-up questions by other board members during that kind of thing. Now, what you could say is that that's really interesting. Can we get that on a future agenda? Because I have some follow-up questions about that. Totally fine. But you wouldn't want to have that engage in that discussions about that. And the other thing I would say is that board members often get in these kind of updates, information that is not intended to be for public consumption or confidential. Now, it ultimately may be public record, but what I would suggest to any board member getting it, that is not for you to decide, or anyone to decide, that other than if there was a public records request, and then it would have to go through some analysis, because even things that are on the face of them public records, they may not have to be disclosed, certain information, if it had student names, or it had some private information about some personnel, or some proprietary information. There's a number of categories that would warrant that it be kept from disclosure. And it requires an legal analysis. So just because it came over a public forum and it went to the board, don't assume that it's a public record. You'd want to make sure that and honor whatever confidentiality that you collectively as a board have agreed on.
Okay, and I just wanted to clarify. And so when we get that board update, we should not be forwarding that, right?
If that is what well, again, you shouldn't forward it to the rest of the board, because that's an open meeting law issue. You shouldn't forward it if it's been, deemed to be confidential, and that's your practice and understanding. If everybody has already agreed to that in terms of your board protocols.
Okay, I appreciate that. I just wanted to have it cleared up again, because I know that every few years we do go over, well, maybe it's when we get new superintendents. We go, not that you're new, we go over this just to clarify it. And I like that we have done this in a public setting, where I know there's thousands of people watching the live stream.
You're muted. You're muted, Mrs. Ordway. I'm sorry. Nope, you're still muted. Try again.
Cannot be muted. Now I am.
There you go.
All right, goodness. I just wanted to thank you for clarifying that topic comes up every few years. For those that lip read, I'm repeating myself. Possibly when we have new superintendents you're not new anymore, new board members. But it's good that it was in this very well-watched public live stream. So our constituents and members of the district can understand how that works. Thank you very much.
Mrs. Fisher?
Chris, I do have a follow-up just based on that. And I don't know that I've ever heard anybody say it's an open meeting violation for us to get the Friday update. I think the concern I've always heard, and perhaps you can give some clarifying on this, whether that is a meeting concern or not, is oftentimes we will be in a board meeting and something will come up and they say, a question that the public has asked for, or the question that a board member has asked regarding agenda items, things of that nature, and they are put into the Friday update. Is that concerning when we bring it, when it crosses over as a portion of our agendized board meeting, and then the response is not brought back to a meeting, but it's rather put into a Friday update? I think that's the concern I've heard more than anything. As far as the Friday update, it is important that we don't forward it, but it is a public document and we need to be sure that the information in there is accurate. And so that is also a concern of mine, but that's a topic that's not agendized. So if you could just answer whether the crossover from a board meeting to the Friday update has any bearing on being an issue.
I don't see it as an open meeting law issue. I do think that, you raise an interesting issue where, maybe an issue has come up in board discussion, or maybe member of the public raised an issue that you weren't able to engage on it. But the administration has done some further research and come into and is informing the board about an issue that they were sort of weren't ready for, or whatever, or didn't have all the information at the time. It's going to be a case by case analysis. It depends on, whether or not, any of that information is sensitive information or confidential information. But I think, you want to consider, it sounds like there's a lot in this Friday update, some of which is just kind of basic and some of which is more sensitive, particularly when you're dealing with staff or students, for sure. And you might want to consider, part of it is, making clear that this part of the update is confidential and this part is not. And just making it clear that, not the whole thing is confidential, but when you deal with something sensitive, that that part is. So, but I don't see an open meeting law problem in just answering those kind of questions one way.
Great, thank you, Mr. Thomas. And so I think we are ready to move on to the 5 DVUSD board policies that we wanted to discuss this evening.
Okay. All right, so I pulled the policies that you had given me that you wanted to talk about, and hopefully, I'll be able to answer any questions you may have, but I assume that you want to talk about them also amongst yourselves and with the administration. So happy to bring those up for you. And just so you know, I asked our policy staff to sort of pull these up for me. They always, they're used to doing policy reviews. So they generated for me something that was slightly different, which is only that whenever we do a policy review, we pull the policies and we show what's different between what the ASBA model is and what the district policy is. It doesn't mean one is, your policy is wrong in any way. It just means it differs in some fashion from the model. So that's what they gave me. So just take that with a grain of salt, because there's just a couple areas where there's different colors, and I'll explain what those are. So
wonderful, thank you.
Yes. So BBA is just your, spelling out what the board powers and responsibilities are. They track very much the 15341 under Arizona Revised Statutes. This is just sort of a preamble to that, giving you the authority that basically you are under the authority by statute to create all policies and regulations that you need and cover all the laws of the state. And it also spells out under BBA that what are your basic functions, and they essentially say that you have that boards are unique in the sense that we talk about the 3 branches of the federal government being the legislative, the judicial, and the executive one, in a sense, you know, a school board can exercise all three of those functions. But what they do is typically, you know, their legislative function is the policy-making function, but they'll work with the administration to make sure that, you know, they are good practices, that there's something that are as attainable, and that they cover the law. And, you know, part of what we do at ASBA, and I know you're a policy services subscriber, is give you those changes in the law when they happen. Your executive function is essentially concerned with making sure that, you know, the operation follows the board policy. So this is sort of your oversight function, and making sure and delegating this power primarily to the board, to the superintendent and his or her staff in carrying out these policies. And then the appraisal function, of course, is not only your oversight function, but you know, things like making sure the evaluation of your educational program is consistent with the policies and with what, you know, your goals and objectives are. So here's a couple things. I think that the blue is our language that you do not have. And again, it doesn't mean that yours is wrong, but you've made a choice not to have them in there. And so that's, in there as well. So these are your BBA board powers and responsibilities, and these are your followed, you follow all the laws, you have a general knowledge of all the educational aims and objectives, and this is for an individual board member, that you'll work with other board members without neglecting proper share of work or trying to dominate the board, or to act in board members impartially for the good of the district, to accept the will of the majority of the board, and give support to the resulting policy. Again, the blue is the ASBA language. And then to accept the responsibility for the confidentiality for appropriate matters, to represent the board in the district that promotes the interest and support of the district and the board, and to refer complaints to the proper authorities and refrain from individual counsel and action. And there's a whole other, that's a whole other training to talk about what your complaint procedures are and how best to channel those to the area, that, you know, the level that they can best be resolved. And then to perform other duties that you may arise. This is the B section policy. And by the way, okay, I just realized I made a mistake. The blue is your language that you've added to the policy. You've added those in there. Okay. And here's your BCA, the board ethics, and it's very close to what the ASBA model is. You've just exchanged one word for another. And these are the things that we believe board members, and you have believe that board members ought to do by your adoption of this policy. That the board members will strive to improve public education. That's what they're there for. And I think this is the most important policy, frankly, in your entire manual. That you'll attend all board meetings insofar as possible and become informed about issues considered at those board meetings. So you show up to the meetings and you're ready to participate because you've learned about those issues as best you can. You recognize that decisions can only be made after discussion, so that you're not bound by a particular position. You're ready to hear new information, ready to engage in discussion with the rest of your board, and then only then you make a decision. That you have, you exercise your independent judgment, and you don't surrender that judgment to other individuals, and that you encourage the free expression of opinion by board members and seek systematic communications with the board and students, staff, and other members, other elements of the community. That's your language. So there's a system in place so that we make sure that we're hearing all the voices of the community, not just the loudest ones.
Mr. Thomas, I do want to
Yes.
correct you. You were right the first time.
I was right the first time?
Yes.
I'm sorry.
The blue is language that is recommended by ASBA.
Gotcha.
And And I think the red is what we have, but is not necessarily language.
Right. Okay. I apologize.
No, that's okay.
And
I just wanted to
yeah.
make sure we we got it worked out there.
Yeah. You can see I don't actually do reviews. I do, I
No
oversee policy
problem.
services, but don't do the reviews. So, yes, okay. And so, and you have, this is provision that you have that ASBA does not recommend that you work with other board members to establish effective board policies. And this is your language, meet the requirements of ARS 15341. So when you see it stricken out, it's not stricken out. It's actually in your policy. So this is just the compare document that we created. That you delegate the authority for the administration of schools to the superintendent. You could communicate, and this is a really important reason why we have school boards. You communicate to other board members and the superintendent expressions of public reaction to board policies and superintendents and school programs. You're the eyes and the ears of the community and a conduit to the administration for the community. That you are informed about current educational issues and individual study through participation in programs providing needed information. You guys didn't like our paid for public advertisement there, but that's okay. We understand. That you employ the person's best qualified and you insist on their impartial and fair evaluation. You avoid being placed in a position of conflict of interest and refrain from using your board for personal or partisan gain. You take no private right of action that will compromise the board or the administration, and you respect the confidentiality of information that you have. And that you remember that the board member's first and greatest concern is always the educational welfare of the students attending the district and the schools. And that's why you're there. Any questions about that policy? Or do you want me to just take them at the end?
We'll go through all of them and then
Gotcha.
we'll come back to everybody.
Okay. BHC is board member communication with staff members. This makes it clear that that we don't muddy the waters with muddying the chain of command. That that if an employee wants to talk about an issue that relates to their job, that they're first relating those concerns at an administrative level, and hopefully at the administrative level that's closest to where the concern is, because that's best where it is resolved. There's no anonymous communication allowed that will be considered collectively by the board, because we do believe that that's a question of fairness. That the employee that wishes to address the board in the employee's capacity, if they also happen to be a parent or a resident in the district, they can do so under the general public participation policy, but they need to understand that they're participating as not as an employee, but one of those other categories, and that official communications and will be communicated to employees by the superintendent, so not by the board. So the board will express concerns collectively when it's appropriate, and then that will be communicated to those employees by the superintendent. This is this red language, again, take a big grain of salt with the fact that it's stricken. This is your language, it's in your policy, and we make no judgment about how good it is. The board welcomes the opinion and input from employees and the public in general in all matters, and your structure is noted for official specific business should not prevent communications between the board and all stakeholders, but to channel or such communications must be made in compliance with open meeting law to the extent possible, applicable. So that's just making it clear that we value public input, we value employee input. We just need to be aware of the open meeting law, and they need to understand that that's a restriction on the board and their communications with those individuals. This is the board BHD, which is board member communications with the public. And it basically says that it's sort of also a chain of a command issue, which is that if somebody has a complaint, not a concern about a general policy or maybe an adoption or something that's coming on the board agenda, but something that they have a complaint that in their engagement with the district at a particular level, that they can use the public participation policy at your board meetings, and that they should exhaust their opportunity or their concern at the administrative level. But if they don't, once they've exhausted that, they can communicate with the board in writing. And again, no anonymous communication will be considered by the board, and that official communications from the board or board action is imparted to the community by the superintendent. The new board member and orientation handbook is BIA. And this basically is your protocol for sort of onboarding new board members, and you do have a couple new ones. So this is where it says that we're going to try to get them up to speed as quickly as we can, and we're going to meet with them to make sure that they have everything they need to be ready to go. And it says that a board member or any person designated for appointment of board member elect or the board is to be afforded the board and staff's fullest measure of courtesy and cooperation. The board and staff will make every effort to assist the board member elect to become fully informed about the board's functions, policies, procedures, and problems. And that there's in the interim between your election or appointment and actually assuming office, again, we have an onboarding system where you will receive communications and reports so that you are able to transition to being a fully engaged board member. That you have access to, your policy manual, which is public anyway, and available. Any regulations or any publications by school boards associations. The board president and other members of the administration will confer on special issues or concerns, and board members elect will be encouraged to attend meetings or workshops specifically designed for board members elect. Their expenses at these meetings can be being reimbursed by the district if it's in accordance with the law. And that's them. That's the ones we're going to cover. And again, happy to help with any discussion that you may have or answer any questions you may have. Which one, just let me know which one you want me to go back to and I will.
Okay. I haven't seen anything in the chat, so is there discussion? Okay, Mrs. Fisher, is that you? Sorry, it's not showing up, so I'm
I'm not sure why it's not coming across. I see him there, but it looks weird to the side. I'm not sure how you see it on yours. These Zoom things don't work for me at all either. So part of the reason I brought these policies home or to forward is because I did want to verify if things have in fact changed. None of these policies have been followed. And to the best of my knowledge, I've been told that these policies are inaccurate, or portions of them are. And so my concern is some of the things that we did, and Chris, I'm not sure, I mean, you may or may not have, but some of that red lettering is because historically we did have concerns, we did have issues where either staff or community felt that they could not speak to the board, could not engage with the board. Our board's been through a lot of different roller coasters, as pretty much everyone at ASBA, I'm sure, is aware. And I'm sure majority of this board is aware. However, all of us, I think, agreed at the time that we felt it was highly important that we be available to engage with our community and with our staff while also honoring the system. So it was very important that we, if you come to me as a teacher and you tell me, my principal did X, Y, or Z to me, my first response would be, you need to speak with administrative leadership or the superintendent, or I would pass it on to the superintendent, not respond at all, and say, got this, this is not it. If it was in person, I would direct them to go that path. But the little extra red lettering, at least on one of them, was because we wanted our community and our employees especially to feel that they had a voice, that we are not just people who are going to ignore them, who are going to disregard them. We wanted to make sure that they knew, yeah, this is the one specific. And so that's why we left that in there. And there was a lot of discussion amongst the board at the time when we adopted it with this, of the importance of communicating with staff, not to direct them. I can't assume what other board members know or don't know, but most of the board members are seasoned, and I don't think Ms. Peppermint would either. I don't believe any of these board members currently have ever directed an employee to do something. I think we all understand that's not in our authority. And that's kind of why I kind of just picked a few of these to bring forward. I think we all understand that, but I think it's important that, this is my opinion, I think it's important that as board members, we are available to hear our staff. Obviously, if our staff wants to come to us for a complaint specifically on the superintendent, then it is important that we bring it to a board meeting and then take a different route. But I'm not talking about for punishment or for really any of that type of stuff. I'm talking about supports they need. Historically, in the past, I've had teachers come to me and say, one of the things that's really difficult for me as an art teacher is I don't have enough supplies. I don't have enough camera. I don't have, do you have any ideas? And beyond budget items. And I'll say something like, well, we could fundraise, or we could see about donations, so those are the types of things that are really important. They aren't district business. They aren't taking authority. They aren't serving as an administrator. Without going into specific detail about communications that have come to me, it's been communicated that that is not the case. That is, we no longer want that in our district. And so I brought these forward. If that is true, that we no longer want that in this district, we as a board need to decide, bring them back, and remove the portions where we are going to be open to communicate with our staff, our community. We are no longer going to visit campuses. We are no longer going to, unless there is a specific event, we are no longer going to, if that's the desire. I don't know that that is, but if it is, we need to correct the policies so that we don't have employees or that violate the policies. And so that was why I brought these forward. And so I guess the rest of the board would have to tell me if that is in fact what we are looking to do as a board.
So that is not my understanding of how we are operating. There is a chain of command, and there's official business, but if I have a conversation with a teacher at the grocery store, that's not, is that what your kind of conversation you're talking about, Mrs. Fisher?
No, even think back when we first were elected in 2014. The very first thing I did 2015 was I contacted each of the principals and said, I would like to just see your school. I'd like to see you. I visited every single one of our schools and just spent a little bit of time. How are you doing? Engaged with them. They showed me some programs. Sometimes they said, oh, look at this, our new cool thing. Oh, that's great. That's interesting. Because I felt it was very important that we, and I think it's actually in statute, that we are to be aware of what is happening on our campuses, of our community. We are to be available so that we can make sound decisions.
Okay, thank Thank you for
It was
clarifying that.
communicated it was communicated to me that is no longer the case. So that was why I brought these forward.
So for that in particular, prior to the pandemic, we actually have a board, we as a board sign up for different schools. So I believe we did that before in your
Absolutely.
previous term. We were still doing that. We had the list. Obviously, we are not doing it this school year for reasons that are obvious. It is not my, it is my understanding that when things are opening back up to allow board members back on campus and we're able to relax things, that we would go back to that. There has been no discussion amongst board members to change that. We at one point that might have been some of our goals. So I've never seen that official communication, and so I would have to, I would defer to other board members, but it's not my understanding that we will change how we do that going forward. The process though has changed a little bit from when you and I originally began serving together in 2015. And that is that we do go through the superintendent's office to schedule those or okay those visits first, as opposed to what we did before.
And it may be that we need to just change the AMG, or maybe change, because the AMG still says that we will inform the superintendent's office. What was communicated to me is that we are to speak to no employee whatsoever without explicit permission from the superintendent. And so again, that's not in our policy, so it's not in the AMG either. However, if that is the direction that we are going to go, I think it's important that we document it so we ensure that our employee or employees are following those policies accurately.
Mrs. O'Brien, can I ask a clarifying question?
Yes.
Dr. Finch, have we received some information? I'm not understanding this, and I'm feeling like it might be perception, but I don't know. So if you could let us know if any of that has changed and what has changed due to COVID and special circumstances with that, I'd be very interested.
Yep, thanks for asking. Ms. O'Brien is correct. That's how we did it pre-COVID. We actually assigned board members to schools, and we'll continue to do that. Worked great. It's almost like adopt a school, and we scheduled, it was part of our goals, if I remember right, to be more active with our employees. I think the other example, Ms. O'Brien said, we're running into staff members at grocery stores. That's obviously going to happen. You're recognized. You guys are rock stars, so they're going to say hi to you all. That's going to be normal. Probably from my perspective, that there might be some confusion, and maybe Chris can add to this. I think the first line of BHC is the key.
Right.
It's an employee will first communicate on school-related matters with administration. That's the key. So often board members, and again, I've been a superintendent now for 20-something years. That's mistake number one that board members make all the time. And they do it because they're trying to help. And so when a staff member comes up to them and says, A, B, and C happened to me, can you comment on this, or can you help me? And you say to them, yeah, I totally agree that shouldn't have happened to you. Keep me in the loop. I'll see what I can do. That's my job. And so and I always tell board members, and I repeat, I've been repeating for 20-some years, your standard answer is listen first. Second is say, hey, did you talk to that teacher about your student's grade? Go back to the closest connection where the problem can be solved. And it's that chain of command concept. So if they come to you with a problem, don't solve it for them. Punt them to the right level where they're supposed to go. And then as it climbs the chain of command, and it gets to the superintendent, then you may become the judge and jury if that situation doesn't get resolved. So if you've already commented on it or agreed with the staff member or set up a meeting and started solving the problem, then you're gonna have to recuse yourself because you've already tipped your hand. So I don't know if I'm right here, Chris, but that's in general, I don't have a problem with board members speaking to employees. That's not a problem. It's when we try to be helpful and we don't need 6 superintendents, we only need 1.
Yeah, I agree with what you're saying. Absolutely. The policies are there to give fairness to all and to, respect each other's roles between the operation of the districts and the governance of the district. And, ultimately, as Superintendent Fitch says, is that, ultimately, if it becomes if it's a serious, matter between the employee and the school, and it becomes a disciplinary matter or something that the board has to resolve, you want to make sure that everything has been fair in terms of process before it gets there, so that when the board ultimately takes it up, that that they can make a fair determination. So, I mean, it's sort of common sense that the best decisions are made at the closest level. I mean, that's why by the way, we support local control in school districts, is that we don't think Washington ought to be, governing our local schools, because we think that we do a better job because we're closer to the problem, or closer to what we're trying to do. And so it's the same thing with staff issues. That they're best resolved at the problem, wherever the problem is, if the perceived problem is, before it ever gets to the board level. And I know, and I totally I mean, I was a board member myself in a district. I got these kind of approaches, and you really do want to, be approachable and let people know that you care. And it's just, you got to be, it's an art. And I know that some of you veteran board members have done this, where you just in a nice way say, I really appreciate this, but let me find the person that you need to talk to. And you can always ask for a follow-up from the administration directly, saying, just to make sure that it was resolved, without taking on the problem yourself.
Mrs. O'Brien,
Yes, Mrs. Orde.
I know that I've already spoken. I didn't know if Ms. Paperman wanted to speak, because I can wait if she does.
Mrs. Paperman?
Well, I would like to thank Mr. Thomas for the clarification, because I have a better understanding being a new board member, as long as we're not in violation of discussing anything that has to do with the agenda or topic that we're going to be speaking as board members. So I feel more confidence now, if I'm going to be meeting, going to district events, and I get nervous if I see three board members there, that it is okay as long we don't make the discussion, or if I sit in a parent organization, as long I'm not making those discussions. So I thank you for the clarification.
You're welcome.
Mrs. Ordway?
Yes. So I think when we go back to some of the agreement and changes or additions, subtractions to the policy, what is that? Especially if you've been in the district as a parent or a board member for a while, you think in your head that, oh, I know who this question should go to. I have this question. So if it's curriculum, I'm just going to shoot out this quick question to Dr. Galligan and say, hey, whatever. Because I'm a board member, she's going to most likely get this really cool response that has flow charts and colors and whatever, and send that to me because she feels like that's what, you do to respect a board member. As opposed to if I had that question, send it to the superintendent, he would answer it, and then send it, the work to that person as it needed to be. So I think that when we send, the reason why we don't send the questions directly to staff is because we don't want to impede their work schedule. And knowing that because you're a board member, they're just going to do it. So I think that was part of it. The other thing is we do have in place our communications with the staff. We have our ethics. But my question is, other than if it is a statute, it is incumbent upon us to self-regulate, because there's no one that's going to, there's nobody that has an authority unless it's a statute to say, hey, you're not doing, you know what I'm saying? So we really have to be very responsible to follow the policies that we're creating.
Yes, I agree with that.
Do you have,
If you could explain how we don't have as board
Yeah.
members, we don't have that,
Sure.
that right.
Yeah, I mean, these are governing board policies that are agreed to by the board, and they're all individual board members are bound by them. You are correct in pointing out that, a board member that doesn't follow this, there may not be any specific, penalty for doing so, it would seem. However, that doesn't mean that there aren't any consequences. I mean, the consequences could flow from, let's say that, again, as Superintendent Finch mentioned, that a chain of command wasn't followed, or that the board member was involved in an inappropriate way at a low level, and it ultimately got to the board. Yes, there could be a real question of that board member's impartiality. There also could be questions, particularly if, say, the board member was out to get a particular employee fired, and it turns out that this employee, turns around and sues the district once they're terminated or whatever, and the district is found to be liable. But they can also, if the board member was acting outside the scope of their service, could be named in that lawsuit on an individual basis, for which they would not have protection by by indemnification of the district's insurance policy. So that's another, kind of risk that you are taking that may not result in your removal of your board seat, but it is something that to be concerned about. Not to mention just putting the public, resources at risk by such a lawsuit. So, the reason. The worst thing that you can have in any kind of complaint about fairness from somebody who's a staff member or even a community member is for somebody to point out that you're not following your own policies, because that's almost, if I were being the attorney for that in that lawsuit, that's what first thing I would point out. Here's what their policy says. Here's what they're doing. And, it's pretty strong inference there that something is happening here that's not fair.
Thank you. And thank you, Ms. O'Brien.
yes, ma'am. Sorry, trying to check the chat. So are there any other comments or questions? All right.
Ms. O'Brien, so long as nothing has changed, then I don't know that it's necessary for us to discuss them. I brought them forward because I was told it had changed. And I'm not talking about people bringing concerns forward. I think we all are very good at putting them to the superintendent rather than to the individual employee, even if we've been here for a long time, because we don't know the status of all the employees. They could be gone. They could be themselves a potential to come before us at some point. It was the reference had nothing to do with anything of that nature. It was more, I was told specifically, we were to talk to no employees without explicit permission from the superintendent. And that would then be a violation of our policies. That was the only reason to bring them forward. So as long as the policies haven't changed, nobody wishes to change them, I'm good with them how they are. I believe that we very much took into consideration our employees and our community when we established these. A lot of thought and discussion went into them during a time when there was a lot of volatility. I don't know if that's the right word, to use a Ron Bear word, shenanigans, or whatever you want to say. And so I think that these were very thought out by the board members at the time. And I'm glad to hear that they are in fact still our policies. So that was the reason they were brought forward. Thank you.
Okay. Thank you very much. Thank you, Mr. Thomas, for joining us this evening and sharing your expertise in open meeting law and reviewing a few of our board member policies with us this evening. So
My pleasure, and I'll turn your screen back over, and thank you so much.
wonderful. Have a good rest of your evening.
Thanks, Chris.
Thank you.
Okay, so moving on to item 3C, it is our trust board discussion. And I believe it looks like we have a presentation for that. Mr. Miglerino, are you going to be helping us out with that?
Yes, President O'Brien, members of the board, Dr. Finch, just in the interest of time, I'll try and be brief, but wanted to go through some information regarding our association with Valley Schools. The presentation I have is kind of an adaptation of a presentation that was given to the board, a different governing board, obviously, in 2017. So with that, I think I'll just jump right in. Just talk about different ways that we can self-insure. We'll be a Valley Schools overview, talk about self-insurance in general, the benefits of self-insurance, the benefits of being a Valley Schools member, and we'll talk about reserves. I won't spend a lot of time on reserves. I didn't know if that was part of the interest in this topic or not, but there are some slides associated with that. In the Arizona Revised Statute 15382, it does provide for 4 options for a district to self-insure. The first option is to enter into an intergovernmental agreement to pool together with other entities. And this actually is the option that that created Valley Schools. So the 3 founding districts, so Paradise Valley, Deer Valley, and Peoria School District opted to begin our self-insurance with this option. There are 3 other options. One is to create a self-insurance pool. This is through an association of school districts, sometimes referred to as the ASBATE option. So ASBATE is an option for self-insurance for medical coverage. That's a different option than we elected when we created Valley Schools. The third option is to just use a cooperative purchasing agreement. The fourth option is to create our own self-insurance program. And there are different requirements with each of the 4 options. But as I mentioned, we opted for option 1 when we created the self-insurance pool. That created Valley Schools. It started back in 1987, started with our property liability coverage. At the time was called Valley Schools Insurance Trust. It's now called Valley Schools Insurance Group. Then in 1996, we created the Workers' Comp Trust, now called the Workers' Comp Group. In 2005, we created the Employee Benefit Group and also created the Management Group, in which the trust administration was assigned at that time as well to Valley Schools Management Group. And I know many members that are actually on this board will recall in 2017, Valley Schools, we passed a resolution that actually created Valley Schools as a nonprofit public agency pool. Prior to that, it was formed via an intergovernmental agreement, but it is now a nonprofit organization. And that was specifically done to limit the liability of the 3 founding districts to the reason that was created. So self-insurance, we basically we're at risk. We 100% pay all the claims that we receive in all of those various aspects, whether it's property liability or workman's comp or medical and dental claims. And we kind of can mitigate some of that risk by purchasing something called stop loss insurance. So up to a certain threshold, we self-insure. Beyond that, we get reinsurance through a third party. And there is this concept of premium equivalency that we make. So we make a contribution each year that hopefully covers the cost of the claims. And if the claims are not as great as the contribution, then that adds to our reserves. If the claims are greater than our contribution, then we subtract from the reserves. So just the benefits of self-insurance, it eliminates any profit that the insurance companies might make, especially in a fully insured model. They actually set the contribution rate, hoping that there will be a year or years in which the claims do not exceed those contributions, and they get to retain all of that. In a self-insured model, we're actually able to retain any of those excess or unspent claim dollars each year. Also does create the risk that we could have claims that exceed the contribution as well. But investment earnings help reduce the cost moving forward. We can create these customized coverage plans, especially as being a member of the Valley Schools program allows for that. We do avoid a premium tax, which is about 2%. It's a little less than that in Arizona. It does help us create in those customized plans. It does help us with cost containment, and it does help us with being able to leverage this to be able to help with our operating budget on an ongoing basis. I mentioned the stop loss. I'll just tell you what some of these SIRs and deductibles are. We're talking about $100,000 per property claim, $1.25 million on general liability, and $1.5 million on auto liability. So hence the need to have reserves is we are self-insuring. So, and one auto liability claim can easily generate a $1.5 million claim. We've seen that on a number of occasions in our district. On the workman's comp group, the SIR there is $750,000. So we're self-insuring up to $750,000 for any workman's comp claim, and then we buy reinsurance above that, as we do. I failed to mention that on the Valley Schools Insurance Group. And in the employee benefit group, we are covering the first $400,000 of an individual's claims. There are some exclusions in all of these policies, but that's generally kind of where we're at. And then just quickly, I think the benefits of being a Valley School member, and this would be a way of differentiating between those 4 options that allow us to be able to create self-insurance. This is, I think, the things that differentiate being the option that we elected back in 1987 and why we continue to be a member of Valley Schools. So there is accountability and oversight. There are required reviews of the Department of Insurance, and those are frequent. So they happen every 5 years of these examinations that the Department of Insurance does. And we have to, Valley Schools has to actually file their financial audits with them annually. So ongoing reviews with the Department of Insurance, and that does not happen with other trusts. It's not a requirement. And we also, because of how the Valley Schools was created, we do have a member that sits on the Valley Schools Management Group Board, as does the other 2 founding districts. We pool the purchasing power together. So right now on the medical side, our purchasing power is about 35,000 lives, 33,000 lives, something like that, is the pooled purchasing power, where we're only covering about 3,500 lives for the 4,000 employees in our district. So that larger purchasing power allows us to negotiate better contracts with those providers. The accounting is maintained on an individual district basis, so we have individualized accounting, so we know exactly how much is our reserves versus another district that would be a member. And the investment rates of return are much greater than any other way that we would be able to invest the money ourselves. Part of that has to do with, again, the pooling of the investments, but also the different investment policy, formal investment policy that Valley Schools has adopted. And then I mentioned this previously, but autonomy. So the employee benefit plan design is customized for Deer Valley, as is on the agenda for later tonight under old business. A recommendation is made by a benefit committee that is presented to our governing board, and then the governing board ultimately approves what is the benefit package for our employees. And that can be different than any other member of Valley Schools. I mentioned the reserves. So they're basically needed because we are self-insured. We can have good years and bad years, and we've had both, in which we need to have the means to be able to pay those claims. Remember, we're 100% responsible for all the claims associated with us. We just have to have a funding strategy to make sure that we can pay for those claims. And on the medical side, it's really no different. It's just larger amounts due to the amount related to the cost of that particular coverage. This is just a minimum target level of 25 to 50% of the annual cost. At the beginning of this year, we were between 42 and 44%, depending on the incurred but not reported, or what we call IBNR amount. That has to be actually projected. And what that is claims that happen during the period that somebody's covered, but just the claims have not been adjudicated, meaning they have not been processed completely. So there's usually about 2 to 3 months worth of run out to be able to fully understand what the total cost is during a planned year. Just to put that into a perspective, about $11 million, $15.6 million was the amount of the fund balance. Adjusting for IBNR, I would say that's going to be just below maybe $11 million to get to that 42 to 44% number. And that's basically it. I mean, so we have reserves in both the insurance group as well as the workman's comp group. I told you what the deductibles were on the insurance group. The reserves, they're about $5.7 million at the beginning of this year, about $5.3 million on the workman's comp pool. And so I'd be happy to entertain any questions.
Mrs. Fisher?
First I want to thank Dr. Finch for getting us the documents from Valley Schools. There is a reason I asked for them. I'm a little concerned that he indicated there was difficulty generally these things are fairly easy to access, but
Mrs. Fisher, I'm
the
sorry.
reason I wanted,
Mrs. Fisher, I'm sorry to interrupt. Do you have another device on? You have a terrible echo, I think, right now.
just my iPad, I can move it away, my
There you
TV.
go. Much better.
I have a TV for other individuals to be able to
No
watch.
problem.
Is it still getting the feedback?
Nope, that's much better. Thank you.
Then we're good. The reason I had asked for the documents to be kind of provided to all of us is so that we could read through them. I did take time to visit with Tom Boone, who was, because he's the one who originally was one of the founders in this whole thing. He's very highly intelligent regarding self-insured trusts and is the head of Valley Schools. As far as I know, always has been. He's also the writer of the You Suffer, which a lot of people don't know. But the reason I spent a lot of time talking with him and I asked about, because he had kind of asked, well, why would you want to bring this forward? There is a difference between a self-insured trust and an insurance trust pool. And I was under the impression that Deer Valley had their own trust versus being part of a trust pool. I am still interested in having a group for oversight. It would not be the same thing as a trust board. I want to make it clear that at no time did I ever want Deer Valley to start their own new trust away from Valley Schools. I have worked with Valley Schools since 2011 in various capacities, and they are by far the best, in my opinion, for this type of work. For this type of investment pool. And they are very, everything Mr. Migliorino has said is very accurate. They are very well audited, reported. We do hold a seat on their board. The concern has never been Valley Schools. I survived through the raid of everything at another district. And I have never lost faith in Valley Schools. In fact, us getting out, I want to point out, would require us to stay out for 3 years before we could come back. So I don't even recommend that we consider moving our funds. Definitely don't ever recommend that we take apart our trusts. Number one, when you shut down a trust and go fully insured, we would, all those resources, what is it, 20, Jim, you would have to tell me the amount we have in the 3 trusts. But whatever that would ultimately just be used to take down the tax debt. There are very specific regulations into what we're doing with these trusts. What I wanted to bring forward, because it's what we've had at every district I've ever worked for and everyone that I've seen, is there is, and it's always been called a trust board. Deer Valley can call it whatever they want, but it is essentially a committee of the board that does the oversight, where this information is reported. A lot of people don't realize that the money we have at Valley Schools is not on our financials. We do get a reporting every year from Valley Schools at the end of every fiscal year. We get a assessment of where we are. We do get our financial reporting. We also get monthly what our experiences are, what our IBNR is, whether or not we have high cost claims on the horizon, that type of thing. And while I believe, and again, it's just my belief that we believe, we have a great business manager in Mr. Migliorino. I don't believe his intent is to work till he's 90 and never retire. So there will come a point in time when our staff will change, and I believe that we need to have transparent systems in place for the public to see. It was originally an individual from another district that brought to me as a board member, why are you allowing X amount of money to be unreported, unsupervised, you have no idea where decisions are being made. You have no idea what your experiences are. You have no idea. how can we trust your board and you as a board member when you look the other way when in reference to millions of dollars? Because it's not a small amount, it is a large amount. And depending on, and I did explain to the individual that depending on when you pull those documents, if we just funded, because we generally pre-fund our trust, our payments, you're going to have a lot more because our experiences haven't occurred. If you go to the end prior to our funding, it's going to be much lower, but it is still in the range of $25 million with these three. So my concern is, where do we have that transparency, that reporting? You know, when I talked with Tom, you know, I'm sure, and he's right, you do have actuarials that'll come along, whether they sit with Jim or they sit with a benefits administrator or they sit with Heather Mock, and they will determine what our rates are going to be. Who's reviewing? You know, we do have a committee for our benefits, but is that a transparent? One of the issues that we have all the time is we have, and it hasn't happened since I've been on the board this time, it happened continuously for the 4 years that I served, where they say, oh yeah, we all had our secret meeting and everybody thumbed up, and they'll go, oh no, I really did this, or I did this, but nobody saw it. And we had a lot of controversy. My concern is that we have a transparent, clean process to review our experience, to make sure that we are being honest and accurate with our public and with our employees. Oftentimes I'll hear, I don't get the district. I don't know why they can't just put us on the state insurance, because they've read it. They can put us on the state insurance. Is that beneficial for Deer Valley? Absolutely not. That would be a fully insured equivalent for us. But those type of questions come when we're not transparent, and that is my concern. And I don't know if administration has an answer or a solution for how we could do that. I do want to make it clear, my goal is not to leave Valley Schools, is not to reestablish a new trust. It's to have a process for appropriate, transparent oversight of what we currently have from the Deer Valley perspective, because nothing that any of our committees do would ever impact or oversee or have authority over Valley Schools. And so that is the purpose, Mr. Miglerino, Dr. Finch. That's the purpose of what I'm looking for. I'm not looking to reinvent the wheel or change our lives.
Mr. Miglerino, do you have some thoughts on providing some transparency that Mrs. Fisher is requesting?
President O'Brien, Ms. Fisher, yeah, so oversight does exist, as I kind of just really quickly went through in the actual presentation. Maybe not at the same level that Ms. Fisher had described, but there is oversight. The Valley Schools Management Group meetings are open meetings, and there are sometimes people that do attend those meetings. They follow the open meeting law, just as we had just covered with Mr. Thomas. But to add another entity, not a trust, but a committee of the board is what I think I wrote down, is what I heard Ms. Fisher mention, that would do some oversight. I'm not sure what that structure would look like. It's not one of the 4 approved structures in the statute. Not to say that we couldn't have a committee. I'm not trying to indicate that at all. It's just that we would continue to operate the way we are and have another entity of some sort that could provide whatever the board wishes were. We would just have to spell out what those responsibilities are, because at this point, I think there is accountability and oversight. It's just in a different form than I think Ms. Fisher was looking for.
Mr. Miglerino, could you remind me how often Valley Schools Management Group, how often their board meets?
President O'Brien, we meet about 4 or 5 times a year.
Okay. Do any of the other board members have any questions right now? Or, sorry, I'm trying to open my chat.
I
Okay.
have a question. So I think everything comes down where the most saving is for the district and for the staff. So yeah, so it will be interesting to know, well, what is the benefit package for the employee and how much, like out of pocket or what the district is spending.
Right, and we will be discussing that package that's specific to this year coming up shortly in an old business item. And so, Mrs. Fisher, I just want to be clear on what you're requesting is that there is just a more transparent and clear process in what Valley Schools Management Group is doing for us and for us to look at those finances. Is that a fair?
No, Miss O'Brien, I don't want it to, and again, I'm not trying, it may be just a reporting structure that we need to add in, or just where the board it's put in a report somewhere. It could be something as simple as that, because what Valley Schools does, how they invest, whatnot, we have that. But who is looking on our side? Who is determining on our side what our contribution is? Who is determining on our side what reserves we're going to maintain? Who is addressing when we have an IBNR that is just too high? That's something that we always did in our trust board. So it may not be a board or a committee at all. It may just be that we have a level of reporting that is transparent for the public. It could be on the finance page where we have, this is our status, obviously not releasing any confidential information. These reports don't have confidential information. But having that transparency, and it may be having our benefits committee meetings be open to the public or be Zoomed or whatever it is, so that if the public or if an individual employee is questioning, hey, wait a minute, what's going on with this, they can watch. One of the aspects that we had when I've done this in the past, they were always open meetings. We always had seats to the side, people could watch. Could they speak and participate in the meeting? No. But they could witness what was occurring. And it's not Valley Schools, it's what's happening in our world, in our control, what we are doing. Once it goes to Valley Schools, it's invested and whatnot. And I'm sure Mr. Michelino is watching that, and whatever other business manager comes in would also be watching that. But it's the other aspects of what is occurring at Deer Valley that I'm seeking transparency in.
Okay.
Does that make sense?
I believe that is much more clear to me. Yes. So, Mr. Miglerino, could you, in the interest of time, because we are at a 9:15, maybe answer those questions for us? And initially, I would say put them in the next Friday update, because we are going to have a period of time. We're not going to meet again until March 23rd. So. Not the next one, because the next one is a couple of days, but maybe the one after that. Sorry, I realized my timing there. And then we can all read that and evaluate from there what that is looking like right now, Mrs. Fisher, and how we possibly improve upon that going forward. Does that work for you?
Absolutely. I'm just looking for transparency, and if you have questions, you're more than welcome to contact me.
Okay.
Thanks.
Awesome. I appreciate you for appreciate you for clarifying that. And Mr. Miglerino, are you good with that? Or with those questions, Mrs. Fisher's questions?
President O'Brien, I understand that you guys are asking me for a plan to increase the transparency.
Actually, I think what I'd like to know now is the answer to the questions on how it's done right now. Like, what is the question she asked, who's doing that and how is it done right now? If you have suggestions about how we could improve that in the future, that would be a bonus, icing on the cake.
Understood.
Okay, wonderful. Thank you very much.
Mrs.
And
O'Brien, can I
Ordway?
just, yeah, are we the word transparency is used in so many different ways now. Are we looking for access to the information, more public access to the information that has to do with Deer Valley's portion or active part in the trust?
I believe, yes, that is how I interpreted Mrs. Fisher's questions. I think we want to, well, one, understand what is happening right now. And two, yes, I believe what she's striving to achieve is to have some more transparency than what we have right now. Because as we've said, as was stated, Valley Schools has, open meetings, those documents are available. I think we're looking for the steps in between there and how we got to our recommendation and some of the questions she asked. So I think it would be helpful for us to understand the process that we currently have and then determine exactly, yes, the goal for transparency or access from the public.
Okay, because sometimes the word transparency has a connotation of not being forthright or honest. And I just want to make sure that we make that clarification that it is more for access of the information and understanding with the information, how it pertains to us and what we do with it.
Yes, I would think that's a fair assessment. Okay. Thank you, Mr. Miglerino, for that presentation and for answering our questions. And now we're going to move on to 4A in old business. And if I could have a motion, Mrs. Ordway.
Sure, I would move that the governing board approve the administration's recommendation to approve the 2021-2022 Employee Benefit Committee recommendation.
Do I have a second?
I second.
Thank you, Mrs. Paperman. Mr. Miglerino, it looks like we are going to hear from you again.
President O'Brien, members of the board, Dr. Finch, this is the same information that we shared in a preview at last week's meeting. Again, very quickly, just in the interest of time, a 0% increase is what we are, the actuarial is projecting for us for next year. The committee did want to incorporate a 4-tier option for the medical benefit. We only had 2 options, employee plus an employee plus family. The 2 new tiers would be employee plus spouse and employee plus child or children. Those would be 2 more cost-effective options for our employees to be able to pick up dependent if they so needed to do so. Those are the really big changes, just the tiered option. As I mentioned before, slight increase on the life insurance rate for the district-sponsored plan, the district-paid plan, I should say, and then the wellness program, again, trying to shore that up by providing an additional incentive. So the recommendation has not changed from last week, and just would be willing to answer any questions. Just also wanted to recognize the committee that looked at all this information, digested everything from loss ratio to annual evaluation by United Healthcare. Lots of information that they went through over the meetings that we had over the course of this year. So I just wanted to recognize them.
Thank you, Mr. Miglerino. And yes, thank you very much to the committee members who spend all that time and work on the benefits recommendation, as well as you, Mr. Miglerino, who is it you? Yep, Mr. Miglerino right there, and Mrs. Moffett. All right, Mrs. Paperman, did you have some, I believe you had some questions on this topic.
Yeah, basically, what's the package? What is the benefit package for employee, like out of pocket or like, and also even the district, like how much is the district putting into the benefit?
I don't know if I can share my screen. I don't know how much we want to get into the details. So here are the, especially the medical, which is the, I think one of the most costly benefit that we have, both for the employer and then for the employees that may pick up dependent care. And so we can share this information with the board because we did not include it in the package that was uploaded, but we can certainly provide this as well because it might take a little bit more time. But just knowing that we're actually asking you to vote on it this evening, I wanted to be able to at least share this. So there are no cost options for our employees. And so I don't know if I can highlight this or not, and you guys see this. So there's a no cost option here for our high deductible health plan. Employee pays zero cost. The employer pays $6,375 plus makes a contribution to their health savings account that's not included in these numbers if they make a contribution. So it's voluntary and it's a 2-for-1 amount. So for every dollar they put in, we put in $2 up to a maximum in their health savings account because this is a high deductible plan. But there's also a traditional PPO plan, and this is differentiated based on a hire date. So we grandfathered some folks in. It's a $20 monthly cost for our employees that were hired prior to 2012. So that cost for them on an annual basis is $240. The district pays $7,650 for a total of $7,890 combined. If an employee was hired after 2012, same plan, but different cost structure, the employee is paying $150 a month for this option. The district paying just over $6,090, same cost for the plan, again, because the plan is the same dollar amount, it's just a different in the cost share. And this is, again, a voluntary choice for the employees if they want this particular plan. Again, there's a free option for all employees.
Does that answer?
Thank you. Yeah, remember this review in my district. I know the importance also, if we're going to go to the hospital and urgent care, and that's one of the concerns that we educated our staff in Glendale. If you're going to go to the hospital and urgent care, the money adds up for the district too. So I know that there's a lot involved with benefits.
Wonderful, thank you.
And I would just make a comment that, so I'm sorry, President O'Brien, Ms. Paperman. So that gets into plan design. I thought you were specifically talking about cost for the coverage itself, but in plan design, there have been no plan design changes in the plans themselves. So no change in the deductible, no change in the co-pays, whether that's for urgent care or emergency room, or seeing a specialist versus primary care physician. All of those components are remaining the same in what's in the plan for consideration tonight.
Thank you for the information.
Mrs. Fisher, you have a question?
Is there, I mean, why are we differentiating by date of hire? Is there something in our language that says 10 years of service, they pay less? Or is it going to drop at some point for our employees who were hired, say, in 2013? Or is there, I'm just curious as to why because that's a significant difference for our employees. And they don't make that a lot of money. So, I mean, I'm just concerned.
President O'Brien, Ms. Fisher, that was a previous decision made many years ago, back around 2012. And we grandfathered in the employees that were hired prior to that date, and to allow them to have the choice between either the high deductible plan or the PPO plan. And at that time, we made all the new hires, the default plan was the high deductible plan. What ended up happening is we had some adverse selection where we had, our youngest population on the high deductible plan and some of our older population on the PPO plan, or the more expensive plan, if you will. And so the benefit committee reevaluated that and said, well, there should be a cost for anybody that wants the more expensive plan, but we want it to be a lower cost for those of us that had the option at one point in time for either plan. And so they differentiated. It has nothing to do with years of service. It had to do at the time that this was put into place. So that is the grandfathered date. And we have this in several settings where when that decision is made, we try and hold those people harmless, or in this case, differentiated. They weren't held completely harmless. And that they still have the option. All employees have the option for the high deductible plan at no cost.
Do we have, well, I guess two things. Number one, do we have an initial contribution to their HDHP? To their HSA?
President O'Brien, Ms. Fisher, yes, we have a strategy with our health, high deductible health plan, or HSA payment on a 2-for-1 match. So for every dollar they put in, we put in $2 up to, I believe it's up to $1,200 of district contributions. So if they put in $600, we would put in $1,200. They would have $1,800 in their HSA.
Per year?
Per year.
Okay. Are we doing any education with employees to understand how to utilize that high deductible healthcare plan for the purpose of, because it rolls, a lot of them don't understand how it rolls and how they can build that cost. Do we have education regarding that plan for our employees?
President O'Brien, Ms. Fisher, I would say, yes, we do. But just to be completely honest, it is still a difficult concept for people to grasp because they're averse to the risk. The benefit of the PPO plan is you have a definitive amount that, every time you're a doctor, you're only going to pay X dollars in a copayment. With the high deductible plan, most of the employees look at the fact that there's a lot more exposure that they have. And that is true, but for the vast majority of our employees, it's never realized. And the contribution to their health savings account is to offset that over time and to promote consumerism. So we do have education that we do regarding it, but I would say if you're asking how effective that communication is, I would say that is a challenge that we face on an ongoing basis.
Okay. I guess all I can say is I'm highly concerned after seeing that. but it's gone through the appropriate committee but I do hope that we at some point have a more in-depth conversation about our benefits that we offer within Deer Valley.
Mrs. Ordway?
No, I'm ready to have you call the vote if you're done.
Okay, I just have one quick comment and then we will call the vote. And I do appreciate all the work. I too would like to have further discussions about those differences between the employees pre-2012 and post-2013 for in the future. So, all right, having said that, I will call the vote. All those in favor say aye. Aye.
Aye.
Any again? Oh, four, okay. 4 ayes and no nays means it is approved unanimously. May I please have a motion on the agenda?
Yes, I would move that the governing board approve 5A through F.
Is there a second?
I'll second.
Thank you, Mrs. Fisher. All those in favor say aye. Aye.
Aye.
Aye.
Any nays? Hearing none. All right. Unanimously. We are now into governing board reports. Mrs. Paperman, do you have anything to report?
Well, I would like to say that I did attend the wake of one of the students that had an accident, and I would like to say to the family of they are all in my prayers, and the pastor that he gave an amazing sermon. So it was a very difficult just to be there, and I have the families in my prayers. Thank you.
Thank you, Mrs. Paperman. Mrs. Ordway?
I too have our students that have passed and the families that remain. It's always very heartbreaking as we've got those 35,000 kids that we care about. A little bit of a shout out to the flight team. Excellent. I want to make sure that you guys look to see who's taking care of them because they always take care of us. I'd wish everyone a healthy and a happy, safe spring break, and we're coming back after this spring break. It won't be the spring break that lasts till fall. And again, thank you to the employees, the families, and the community for supporting us on this very difficult, sometimes challenging journey. With all the information that comes in, we're bound to have some misinformation here and there. A couple of glitches in the system, but since we are continuous improvement, we monitor and adjust as is necessary. So I miss Dr. Seuss Day. Yertle the Turtle will have to wait till next year. And I look forward to listening to the rest of the board members' reports and Dr. Finch. Thank you.
Mrs. Fisher?
I'm not going to speak about the students that that we have lost or because I don't think I can keep composure. However, I do appreciate the flight team as well. I do have a couple of requests that have come. There was one email that we received. Actually, I don't know who all received it. I received it, and I did keep Dr. Finch on my replies, so he may or may not remember which one it is. But there has also been questions that have been brought to me since then, and I don't know the answer. I know where we were years ago, but I don't know the answer now. So for the superintendent or whomever wants to provide this. I would prefer it be provided in a way that it can be communicated to the public, because it doesn't do any good to tell me the answer and then I can't provide it to them. The two questions that came following, and it wasn't just that one email or a couple of emails, it was also stuff that's happening in Washington and other places. So do we have teachers that are teaching the 1619 project or critical race theory, regardless of what curriculums have been adopted? And secondly, I know we always work with individuals who may have different needs, but are the district bathrooms open to be used based on gender identity versus biological gender? And what steps can the parents take to ensure they have full information that they can verify? And I don't expect that anybody would have the answer to those questions here. So if you can just provide information, that'd be appreciated. Secondly, I would think we all received that the state financial report came out. There's a lot in that report. I really hope everybody will download the data file. I really appreciate that the state has started to provide that data file, because some people are data junkies and we like to go through it and review it on our own. One thing that was very concerning, because I know that we have made a great effort to push raises to our staff, to our employees. I was very, very, and I haven't had a lot of time to digest it, but I was very concerned that our average teacher pay is not even up to the state average teacher pay. And I know it's not far below it, but we are one of the largest districts in this state. And with our administrative cost going up at least 3.5%, I don't see how we could possibly not be at least paying our teachers at the state average. Because if we're not paying our teachers, I guarantee we're not paying our classified. And I know we're gonna have a lot of discussions about this, but I just wanted to say that that is very concerning, that we are not even average when we are one of the top districts in this state. The final point I want to make is I really appreciate Ms. McCusker, Dr. McCusker, providing so much information in our Friday update. But I don't think she understood my comment or my statement. And so rather than putting forth so much work, it would be so much easier if they just asked for clarity, because that was a lot of work that we were provided information. The point I made at the last board meeting is not that our district does not do a good job about partnering with others or transition. Deer Valley does wonderful things with our special education students in many ways. The point I was making is that right now, one of the things that's very big is the ESAs. And one of the areas that all school districts, to the best of my knowledge, not just Deer Valley, all school districts. There may be one in the west side of the valley, but I'm not positive. I haven't had time to look. Is that we drop off our special needs students at seat time. The state allows special needs students to attend school to age 22. There are some comprehensive plans that have been shared. That is my concern, is that there is some things that we could do, and I think we need to have a meaningful discussion. Otherwise, parents like myself are forced to utilize ESAs to fill in that gap. And it is a significant service that we could do, especially since we're transitioning these students. We've had them, like in the case of my son, Deer Valley has had my son since he was 3. You know, Bill, the bus driver, who used to be the district office custodian, put my little guy in a car seat for years. Nobody knows my son better than many of the employees of Deer Valley. We can't go anywhere without Barry having his friends. And some of them are staff, some of them are students. But I find myself having to piece out what could have been something that Deer Valley could offer. I hope that we can have a meaningful discussion about options for these students that are dropping off so that they can have a successful life. Not all of them will be able to do some of the stuff that some parents are able to do, especially some of the kids whose parents had to step aside because special needs kids are difficult. So that, and thank Ms. McCusker for the information, but I do still believe that we need to have a very important conversation about what could be for our special needs students.
Thank you very much to all of our board members for their reports. And I'd like to thank once again, Chris Thomas, as well as Mr. Miglarino for the information material provided this evening. We have had some tragic losses in our district recently. And would just like to remind our parents that and guardians and family members that there are resources available on our website and as well as at your schools. So please reach out and let our staff help you. Again, kudos to our flight team as well. And I wish all of our staff I hope it will be a time to relax and refresh over spring break. I know it's still about another 10 days out, but it's important for everybody to recharge. And we are an extraordinary district, and we will continue to become even more extraordinary. So with that, I will turn it over to Dr. Finch for the superintendent's report. You're on. There you go.
All right, couple of things to remind you that are coming your way. One is this Thursday, we have the kindergarten roundup at our district office here. We'll have a bunch of cars zooming through our parking lots, picking up packets and filling them out. So if you want to see that, that's Thursday. Get on our website as we start to enroll kindergartners for next year. As Ms. Ordway referenced, I did have the chance to read some Dr. Seuss today. Did that a couple of times. And with Zoom, you can read to a lot of kids. So I read to a lot of kids that I'm sure I couldn't hold their attention if they were in one room, but they were in multiple rooms. So worked out good. I just had the superintendent's divisional meeting here last week or earlier this week. I think one of our roles in the many groups that we work with, the lobbying groups, is to knock down bad legislation. So we spend a lot of time on that. And then we obviously are worried about budget and all of the pieces that are coming from Washington and how it plays into our district. So that's really one of the roles that we do in the superintendent's meetings. And it's good to get that information. But in general, everyone's hurry up and waiting. And obviously our budget clock is ticking. And so Mr. Miglarino is going to lose more hair if we wait too much longer. So he said he wants the numbers, but he's gonna have to wait, just like everybody else. I did have a great meeting with Kathy Hoffman and Kate Wright, her chief of staff here this week, talking about some concerns that we had. We finally got an audience, and it was a great meeting, so we're looking forward to what comes out of that, and I'll keep you an update on that. Reminder, it's school breakfast week this week, and it's athletic trainer month this month. So make sure you tweet that out or say hi to those folks that are doing such a great job. And then last but not least, I just, a couple hours ago, had a chance to be on the Dean's speaker tour for GCU and had an opportunity to encourage teachers to pick Deer Valley, number one, but also to stay in or go to the teaching profession. So again, trying to maximize Deer Valley's influence in the neighborhood. I get
Awesome, Dr. Finch. Our next board meeting is March 23rd. The other board meetings are posted, and I would certainly entertain a motion.
I make a motion that we end our meeting at 9:44.
Second.
Thank you. All those in favor say aye.
Aye.
Aye, Captain.
All right, everybody have a wonderful evening and week. Bye. We're adjourned.